Seconds to go. Start. So that these statutory authorities can work as real ombudsmen for ensuring that people's faith in the working of these public servants is not shaken. These statutory authorities are meant to cater to the need of the public at large with a view to see that public confidence in the working of the public bodies remains intact. When such authorities consist of high judicial dignitaries, it would be obvious that such authorities should be armed with appropriate powers and sanctions so that their orders and opinions do not become mere paper directions. The decisions of Lokayukta and Uplokayukta, therefore, must be capable of being fully implemented. These authorities should not be reduced to mere paper tigers but must be armed with proper teeth and claws so that the efforts put in by them are not wasted and their reports are not shelved by the disciplinary authorities concerned. It is also submitted by the Petitioner Advocates Association that KL Act was amended by Karnataka Act number 35 of 2015 and certain mechanisms to regulate the appointment of Lokayukta and Uplokayukta and the procedure to remove them is also amended, and the said ordinance has received the assent of the Governor on 19th August 2015. With this amendment, the intention of the state legislature was to make the public feel proud about the establishment of the organization and further make every action of the said organization accountable and in genuine public interest. It is further case of the Petitioner Advocates Association that due to the reasons beyond the reach, there would be pendency of cases, investigation, delay in securing sanction, and related issues, and the learned single judge of this court in criminal petition number 2653 of 2015 has issued a series of directions to the state to ensure that the office of Lokayukta is strengthened, capable officers appointed, officers serving more than the period prescribed weeded out, the public prosecutors appointed to ensure speedy trial, the vacancies to be filled up within a time bound period, and the Lokayukta manual be prepared and circulated, etc. In fact, the respondent state have represented to the learned single judge of this court by an affidavit that it is their endeavor to ensure that the office of the Lokayukta is strengthened at all costs and it would be more accountable and worthy of public trust. The learned single judge of this court has relied upon several judgments of the apex court covering the field to strengthen the office of Lokayukta to ensure that the maladministration is stemmed at the bud. When the things stood thus, the state government created Anti-Corruption Bureau in Karnataka by government order dated 14th March 2016 and issued notifications dated 19th March 2016 authorizing all the deputy superintendents of police in consonance with section 17 of the PC Act for the purpose of investigation. The notification issued by the state government is to defunct the Lokayukta and it would virtually defeat the very purpose for which the office of Lokayukta was constituted, and created a parallel body through an executive notification to achieve the same purpose with lesser intent. Stop.